In this video, we'll be looking at Article 23. Article 23 deals with right against exploitation. We'll just look at right against exploitation now. Traffic in human beings and beggars and other similar forms of forced labor are prohibited, and any contravention of this provision shall be an offence punishable in accordance with law. So traffic in human beings and beggary and other similar forms of forced labor are prohibited, and a contravention of this provision shall be an offence punishable in accordance with the law. So the Immoral Traffic Prevention Act of 1956 was enacted to give force to the provision of Article 23. Begar means compulsory work without enumeration. So this is begar. Begar means compulsory work without remuneration. This is against the spirit of the Constitution, and this is in contravention of Article 23. If someone is making somebody work without remuneration and making them to work compulsorily, then this is against Article 23, and that person can go and invoke his fundamental right. The Bonded Labor System Abolition Act of 1976, the Minimum Wages Act of 1948, the Contract Labor Act of 1970, the Equal Remuneration Act of 1976 were made to make sure that forced labor and the like would not be legally permissible. So all of these acts were made so that forced labor would not be permissible. Article 23 mainly deals with forced labor, and it says that traffic in human beings, beggar and other similar forms of forced labor are prohibited and are punishable by law. So Article 23 deals with right against exploitation. Next we will look at Article 24. Article 24 deals with the prohibition of employment of children in factories, etc. So Article 24 says that no child below the age of 14 years shall be employed to work in any factory or mine or engaged in any other hazardous employment. So this is what Article 24 says. Article 24 says that no child below the age of 14 years shall be employed to work in any factory or mine or engaged in any other hazardous employment. Article 24 does not prohibit children's employment in any harmless or innocent work. I repeat, Article 24 does not prohibit employment of children in any harmless or innocent work. However, there are other laws that prevent child labor even in potentially harmless environments. Article 24 mainly stops children from being employed to work in factories, mines and other jobs that are of hazardous nature. So children here are defined as those below the age of 14 years. The Child Labor Prohibition and Regulation Act of 1986 is the most important law in this direction. There are numerous other acts that deal with child labor as well. In 2006, the Manmohan Singh government banned the employment of children as domestic servants or workers in business establishments like hotels, dhabas, restaurants, shops, factories, resorts, spas, tea shops, and so on. It warned that anyone employing children below the age of 14 years would be liable for prosecution and penal action. So children were banned from being employed even in hotels, dhabas, restaurant shops, factories, resorts, spas, tea shops, etc. and even as domestic servants or workers, or even in any other business establishments. Children here means those below the age of 14 years. Then in August of 2012, there was a total ban on child labor. In August of 2012, the Union Cabinet approved a proposal to completely ban employment of children below the age of 14 years in all occupations and processes. Amendment to the Child Labor Prohibition Act of 1986 were still in progress as we made this video. This is about Article 24. So Article 24 prohibits the employment of children under the age of 14 years in hazardous activities. Further, there is a lot of legislation which also says that employment of children in dhabas, tea stalls, etc. and as domestic workers are also not allowed. This concludes the video on Article 23 and 24 of the Indian Constitution. Next, we will look at Article 25, which is freedom of conscience and free profession, practice and propagation of religion. Thank you.